Okay, great. We're back in the Special Committee on Impeachment Inquiry and moving on to hear from Legislative Counsel Damian Leonard. Over to you. Thank you for being here.
Good morning. For the record, I'm Damian Leonard from the Office of Legislative Counsel. So I've got what I'm going to be talking about is the law behind employment discrimination and specifically hostile work environment harassment. I've got a PowerPoint that I'll walk you through the law on. Feel free to stop me with questions. If we're getting a little bit too deep into the weeds, I might say let's save them to the end just so I can keep you on schedule. But otherwise, we'll go ahead and work through. So let me pull up the presentation here. Great. So we're going to start with federal law. So there's both federal and state law at play here. In general, where they overlap, they provide essentially the same thing at the current point, and Vermont courts look to federal court precedent for guidance when interpreting our own Fair Employment Practices Act, because there are just so many more federal cases whereas in Vermont, we might have only a handful of cases in any decade that make it to the Supreme Court to give us precedent. So often we'll look to the Second Circuit or the Supreme Court. So you'll notice throughout this presentation, most of what I've drawn from is from the Second Circuit or the Supreme Court to sort of color in these statutory words. So under the Title VII of the Federal Civil Rights Act, it's an unlawful employment practice for an employer to discriminate against any individual with respect to their compensation, terms, conditions, or privileges of employment because of the individual's race, color, religion, sex, or national origin, or to limit, segregate, or classify their employees or applicants for employment in any way which would deprive them or tend to deprive them of employment opportunities or otherwise adversely impact their status as an employee because of those same protected categories. So I'm going to use the umbrella term protected class or protected characteristic or category. And that broadly means with federal law, race, color, religion, sex, or national origin. And as we'll see in a minute with state law, it's a much broader list under Vermont state law. So the federal law also includes a provision prohibiting retaliation. So discrimination for making charges, testifying, assisting, or participating in enforcement proceedings is an unlawful employment practice. It's unlawful to discriminate against someone because they opposed a practice that's unlawful under the law. So in other words, because they stood up against discrimination, because they raised the issue with their human resources department or with another supervisor or manager or senior official within the agency or employer. Also included under that is making a charge to an enforcement body, testifying, assisting, or participating in an investigation, proceeding, or hearing under this subchapter. And so this is talking about proceedings through the EEOC or in a federal court complaint. And the EEOC, for the record, is the Federal Equal Employment Opportunity Commission. So, and then that brings us to state law. So under state law 21 VSA 495A1, it is again an unlawful employment practice for an employer to discriminate against an individual because of race, color, religion, ancestry, national origin, sex, sexual orientation, gender identity, place of birth, crime victim status, or age against a qualified individual with a disability. Those are the primary protected characteristics when we're thinking of discrimination. There are also provisions of law that prohibit retaliation, for example, for nursing in the workplace, for requesting a flexible work schedule, things like that, but I'm not going to go into those today. And again, Vermont has a retaliation protection. An employer shall not discharge or in any other manner discriminate against an employee because they've opposed an act or practice that's prohibited under this chapter, because they have lodged a complaint or testified, assisted, or participated in any manner with the Attorney General, the State's Attorney, the Department of Labor, or the Human Rights Commission in an investigation of prohibited acts or practices, because they're known by the employer to be about to lodge a complaint or testify, assist, or participate in an investigation, or because they're believed by the employer to either have already done any of those things or to be about to do those things. The other key piece of the Vermont law that I want to turn your attention to is just the definition of sexual harassment, which is defined as a form of sex discrimination, and it means unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when, and I'm skipping over what's known as quid pro quo harassment, this for that, to go to a hostile work environment, which is the conduct has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. One thing I want to emphasize here is sexual harassment is not just sexually propositioning someone or making sexually suggestive comments. It can include harassment on the basis of sex. So harassment about someone because of their sex. Similarly, all other forms of discrimination, race, national origin, disability, harassment on the basis of someone's protected characteristic is a form of discrimination, and it's illegal under the law. While the Supreme Court first recognized harassment in a sexual harassment case, Meritor Savings Bank v. Vinson, prior to that, several of the federal circuits had recognized harassment in race discrimination cases and other cases like that. And so the sexual harassment case in some ways followed that, even though it became the precedent-setting case because it came from the Supreme Court. So we'll see that as we go through the cases, which I'm about to turn to. But it's really important to keep in mind that while sexual harassment is the most common precedent, this applies to all forms of protected classes, derogatory comments, insulting jokes, intimidation, other inappropriate behavior in the office that's related to someone's protected characteristic is protected in the same way that it would be if it was sexual harassment, or is prohibited in the same way that it would be if it was sexual harassment.
Representative Dolan.
Yes, and I think you were just starting to speak to it because I appreciate how clearly it is worded here, because I think sometimes discrimination can be seen as not allowing somebody an opportunity or a job because of one of the protected classes or categories. And this piece of saying interfering with an individual's work performance or work environment, I feel like those are two different buckets. And so it's helpful to see it here under the sexual harassment. And you're saying that it's covered for the other areas as well. Is it specifically listed out somewhere? Like how would somebody, no, not that,
Yeah.
How would you know, like, it is true for all of these as well? You can't not only not give somebody an opportunity, but you can't create an environment where somebody doesn't feel like they can fully function.
Yeah, and so it is not specifically listed out in current statute. At the very end of this presentation, I'm going to briefly touch on S-103, which has, and language that's passed both the House and the Senate at this point, and is, because there were some minor changes made in the House, it's waiting in the Senate for concurrence. But that would actually define harassment broadly for all categories. But currently we rely on court precedent. for the definition. I'm going to walk through some of the key precedents that sort of guide us on that. This is something we could probably spend a semester going into and really picking through the nuances, but I'll try to hit the high points today for sort of the big hostile work environment cases and guidance that's out there. But yeah, there is not a good definition out there. The EEOC puts out a number of fact sheets and enforcement guidance and guidance for employers that's helpful on this topic. Our Human Rights Commission does trainings on it that contain a lot of this. But a lot of these resources are found in policies and other things. If you look at the state policies that Annie Noonan provided to you this morning, they contain a discussion of some of the high points, again, of what's prohibited in terms of discrimination and harassment. But it's not always, outside of trainings, it's not always the easiest thing for just a regular employee to find if they're not looking for it.
If I may ask one other question. Is there a standard definition for hostile work environment? Because I feel like hearing anti-discrimination, anti-retaliation, and that seems like it's under the umbrella of hostile work environment, but I just want to confirm. So I'm using common language.
So I think there isn't necessarily a standard definition, as I'll get to in a minute, though, that we have case law which gives us pretty good guidance on that. And it's, you know, it's called hostile work environment, but it really is an intimidating, hostile, or offensive work environment is typically the phrase that's used. Sometimes you'll see the cases say an objectively intimidating, hostile, or offensive work environment. For the Supreme Court nerds out there was a really good back and forth between some of the textualists and some of the other members of the court in a case about 20 years ago about whether you needed to say objectively, because, you know, does the word objectively really matter? But it really is intimidating, hostile, or offensive work environment. We use the standard meaning of those terms, and then we are guided by the precedents to try to figure out where the shades of gray fall in terms of whether something falls into that or not. It's a subjective determination when it gets to a court or a panel like the Human Rights Commission or something like that. It's worth noting at this point that in an instance where you're dealing with an elected state official, your remedy under state law is through the courts. So if someone were to bring a complaint against an elected state official, the Human Rights Commission has authority over state agencies, the Attorney General's office, because they represent the state, would not prosecute and then be on both sides. And so your remedy is through the courts here. So you'd be relying on the determinations of a judge. And then that would be subject to review in the Vermont Supreme Court.
Okay.
We've been talking a lot, especially in Annie Noonan's testimony this morning, about existing training policies, but, you know, I guess if it ever gets to that point where the complaint makes it all the way to the court, is not being aware of the law or having the same understanding as your colleagues of defense?
So no, as an employer, you're charged with providing an environment that is free from sexual harassment and discrimination under the law. And there is a defense for employers when you're talking about subordinates. If they're not aware of the subordinate's behavior, they can't be charged with stopping that behavior. But when you're talking about an individual who is in the position of authority with the authority to hire and fire and direct the office, whether it's a supervisor or the top official in an office, that official doesn't get to say, I wasn't aware of the behavior. So it's really, awareness of the law is not a defense. Possibly for an employer, if it's a subordinate, lack of awareness of the subordinate's behavior because no one reported it to you would be a defense. But that wouldn't be applicable in what this panel's looking at.
So I want to make sure I understood what you said about the Human Rights Commission, that an elected official, a charge or a complaint could not be brought against an elected official in the Human Rights Commission?
A complaint could be brought. The Human Rights Commission statute says that it has authority, jurisdiction over state agencies. To my knowledge, that jurisdiction, in the event that it's been brought over or that complaints have been brought, I'm not aware of any ruling as to the limits of that, but the express language is state agencies. It doesn't say elected officials. It does not say the Vermont General Assembly. It doesn't say, it doesn't mention other state bodies besides state agencies. So there's a strong argument that elected officials are not a state agency. And in the same way that, for example, the General Assembly and the judiciary would not be state agencies. They're branches of government, not agencies of the executive branch. There is a bill that was introduced in the Senate this year to expand that language. But that bill has not moved forward at this time. But yeah, there was a bill that was introduced to extend jurisdiction over to the General Assembly and elected officials.
So I don't, remind me if you get into remedies later, if not, I have a couple other questions.
I don't get into remedies later, so I'm happy to touch on those briefly.
So if somebody is found to, in court, to have violated the statute and created a hostile work environment, what kind of remedies are available for the person who's brought that case in court?
Sure. So I'm actually just going to pull up the statute here. And so if you'll see here on B, highlight it briefly, any person may bring an action in superior court seeking compensatory and punitive damages or equitable relief, including restraint of prohibited acts, restitution of wages or benefits, reinstatement costs, attorney's fees, and other appropriate relief. So you can seek compensatory and punitive damages, which could include loss of income, punitive damages for the behavior, compensatory damages for other harm incurred. Restraint of prohibited acts is basically an injunction restraining the individual or the employer that's violated the act from continuing to do so. Restitution of wages or benefits. If the individual was fired for making the complaint, they'd be entitled to lost wages and benefits. Reinstatement, again, if they were fired or dismissed, they could be reinstated. That, as far as I know, is something that's rarely sought in that kind of case, but it is available. And then costs and attorney's fees for coming to court, which allows attorneys to take these cases on a contingency basis, so that they'll get paid if they prevail in the case. And then other appropriate relief gives the court flexibility to provide other relief as it sees fit in the situation. But that's the opportunity to come forward. So typically with these cases, most of the cases will settle before they get to court. For a variety of reasons, the standard of proof under the current law is extremely difficult to satisfy. These cases tend to be emotionally draining. They take a long time. They're very expensive. And often for a victim, there gets to be a point where settling and moving on seems to be the better outcome. And, when you go to court, there's always uncertainty. Even if you have the most ironclad case, maybe one of your witnesses does poorly. Maybe the judge doesn't agree with you on a key point of law. Maybe the jury is not sympathetic. So there are any number of reasons why going to court brings a lot of risks and stress that folks may choose to avoid. But they do have this available. The counsel that the committee is going to be working with, Rich Cassidy, has a lot of experience in these cases and can also provide you with a little bit more insight into that process and what settlements look like and how frequently settlements result rather than a court decision. But my understanding is the vast majority of these cases settle before they ever get to trial.
And who's potentially liable? The individual supervisor as well as the company, or in this case, as well as the state?
So the law prohibits employers from discriminating, but the definition of employer, let me just go to the definitions. The definition of employer is fairly broad. So there is a possibility for individual supervisor liability here. So employer is any individual or other legal entity that employs one or more people in the state, and any agent of an employer. So an agent would be someone acting on behalf of the employer, which could be a manager, a supervisor, et cetera, who takes action on behalf of the employer. And so there is the possibility of individual liability in some cases for managers that knowingly engaged in this behavior or knowingly retaliated against someone who reported behavior. Again, these cases rarely make it to court, and so there isn't a lot of precedent on that. But there is at least one case that I can think of that had found individual liability for a manager.
But in this situation, the state could also potentially be liable as the employer.
Yes.
Right.
So yeah, so in a case like this, there's potential liability for the state through the Department of State's Attorneys and Sheriffs, as well as for the Franklin County State's Attorney's Office.
Okay, well, I kind of got us off track a little bit, but since we're on remedies, why don't you?
Yeah.
No.
Yeah, and so it's worth noting too that employer liability typically arises when the employer fails to respond or fails to respond appropriately when they become aware of behavior. And so an employer is charged with taking prompt action that's reasonably calculated to prevent further discrimination and address what has occurred. So, yeah. Okay. So, getting back to the presentation. All right. So I mentioned the Meritor Savings Bank, the Vinson case. This is a 1986 case where the Supreme Court recognized sexual harassment as prohibited under the federal law against employment discrimination. And it just says the key holding there was the phrase terms, conditions, or privileges of employment evinces a congressional intent to strike at the entire spectrum of disparate treatment of men and women in employment. In that same section of the opinion, they called out with approval a number of those circuit court cases that had preceded this case that I mentioned earlier. And And so I just wanted to note again that this applies to all protected classes, not just sex. And so the next thing I want to just sort of touch on is the reasoning behind protections against harassment. And a later Supreme Court case, Harris v. Forklift Systems, stated a discriminatorily abusive work environment, even one that does not seriously affect employees' psychological well-being, can and often will detract from the employee's job performance, discourage employees from remaining on the job, or keep them from advancing their careers. So in other words, these are the things we want to protect employees against, to allow them to stay on the job and advance their careers, and not have the risk of having a poor job performance, or worse yet, physical or psychological harm. So you do not need physical or psychological harm to show that you've been discriminated against. So what constitutes a hostile work environment? As I mentioned before, a lot of these cases refer to sexual harassment. It's just because this is the most frequent harassment claim that's brought, but it applies equally across all protected classes. So first, for harassment to be actionable, it must be sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive working environment. So again, that's from the Meritor Savings Bank case. And then the Harris case provided that the adjudicator's inquiry should center dominantly on whether the discriminatory conduct has unreasonably interfered with the plaintiff's work performance. To show such interference, the plaintiff need not prove that his or her tangible productivity has declined as a result of the harassment. It suffices to prove that a reasonable person subject to the discriminatory conduct would find, as the plaintiff did in that case, that the harassment so altered working conditions as to make it more difficult to do the job. So that's the key here. We're not looking to see if productivity declined. We're looking at whether the discriminatory behavior made it more difficult for the alleged victims to do their job. And then getting more to what is severe or pervasive. And this is the key piece here, is it has to be either sufficiently severe or sufficiently pervasive to impact the work environment. And this is where most of the case law in the last 25 to 30 years has focused on where do we draw the severe or pervasive line. And so a later case, a 1998 case, Farragher v. City of Boca Raton, which involved ongoing harassment by supervisors of the lifeguards in Boca Raton, provided that Title VII does not prohibit genuine but innocuous differences in the ways men and women routinely interact with members of the same sex and of the opposite sex. A recurring point in these opinions is that simple teasing, offhand comments, and isolated incidents, unless extremely serious, will not amount to discriminatory changes in the terms and conditions of employment. So that's sort of the floor. And then Perry v. Ethan Allen, which is a Second Circuit case relating to a furniture maker in Vermont from the late 90s, said the incidents must be more than episodic. They must be sufficiently continuous and concerted in order to be deemed pervasive. So this is getting to what is pervasive. They have to be continuous and concerted. It's important, and we're going to get to this later, this doesn't mean that they have to go on for years. This can mean that they're continuous over a period of months or weeks even.
So question, and maybe you're going to be getting to this, but and maybe we're changing the standard in 103. I don't recall if we are. It's been a little while since I've read that. But why does it matter about severe and pervasive? I mean, have any courts just looked at, does this undermine one's ability to do their job? I mean, why it seems like that should be the question. Would a reasonable person find whatever the behavior is of the discriminator, the harasser, if a reasonable person wouldn't be able to do their job, that should be enough. I don't understand. They seem to back into it by deciding if something is severe or pervasive. Or have we fixed all that?
We,
I think I'm hung up on this sufficiently, but yeah, well, we're on this.
right, so this is court precedent. And a lot of the severe or pervasive, this is still the law of the land. S103 would remove the term sufficiently severe or pervasive and just say discrimination that interferes with an individual's work or creates an intimidating, hostile, or offensive work environment. And I'll speak to that later. The severe or pervasive standard, as I understand it, was originally brought into the case law to sort of create a cutoff saying, you know, we're not going to, we're not going to turn Title VII, the federal discrimination law, into a civility code, is what the courts wrote time and time again. What we're doing is we're prohibiting severe or pervasive discrimination. And so the courts have struggled with this idea of where is the line on severe or pervasive. And one of the challenges that's come up is that line on severe or pervasive varies depending on the judge, depending on the circuit or state that you're in, and depending on the facts of the case. It's often hard to figure out what is sufficiently severe or pervasive. And depending on who writes the decision, you can end up with, read these decisions and end up with two different lines. And so that has been a challenge. And you'll see with the decisions, and this is part of why we could spend a semester working on this, is trying to figure out how many incidents and how frequently do they have to be for it to be pervasive? How severe does something have to be severe? And you've ended up with very, very different decisions, even on that, where some courts, turning to sexual harassment, some courts have said physically touching someone in a sexual part of their body, that by itself is sufficiently severe. So that's an invasion of someone's personal space, is sufficiently severe to be sexual harassment. You have had other judges who have said it was an assault, but it wasn't a rape. It's not sufficiently severe. So the decisions are not consistent, and I'm calling those two out because they're two extremes, not because this is the prevailing law of the land. I've tried to focus on what the prevailing precedent is in the Second Circuit and in the Supreme Court, and on cases where we have clear precedent. You tend to see more variation of district courts than of the circuit courts, but even among the circuits, there's differences between the Second Circuit and the First Circuit and the 11th and the 9th and so forth. And it makes it very challenging to know exactly where that line is. In recent years, a couple of states have eliminated the severe or pervasive standard or started considering eliminating it. Vermont is one of those states that is considering eliminating it with S103. But for now, severe or pervasive is the law of the land. So S103 provides some idea of where this General Assembly has moved or is moving on the issue, but it still hasn't gone to the governor's desk.
So before I get to Representative Dolan on this, so the way I'm looking at it, this is very helpful, and we're trying to figure out what lens or the lenses that we might be looking at behavior of the state's attorney. And certainly one is, what is the current state of law in both in statute as well as court precedent. But we're not tied to that. I mean, that's not what we have to necessarily apply in our situation. So I think it's helpful that there's S-103, which is another lens, which is following a lot of the precedent from what I understand to look at this. But we have a separate lens that we're presumably looking at and we'll continue to discuss, which is how is whatever this behavior is affecting the provision of services to the residents of Franklin County? I mean, how is it undermining the public trust, et cetera, which kind of adds on top of this. But I just wanted to kind of ground us on why we're hearing from you. And you say that that's the law of the land, but that's not necessarily the law of the impeachment process. And just to remind everybody that.
Right. And that's a very good clarification. I'm just here to talk about employment discrimination.
Yes, yeah, no, I understood. That's exactly what I'm asking you to do, but just for the rest of the committee and for whoever's watching, just want to give that context, so.
Yeah. So turning back to severe or pervasive, we have this case, Howley v. Town of Stratford, which involved a fire lieutenant in the Stratford, Connecticut Fire Department. And the court said, the Second Circuit said, usually a single isolated instance of harassment will not suffice to establish a hostile work environment unless it was extraordinarily severe. The plaintiff must either demonstrate that a single incident was extraordinarily severe or that a series of incidents were sufficiently continuous and concerted to have altered the conditions of her working environment. And then in finding that she had established that a single incident was extraordinarily severe, the court wrote, although the defendant made his obscene comments only on one occasion, the evidence is that he did so at length, loudly, and in a large group in which plaintiff was the only female and many of the men were her subordinates. His verbal assault included charges that the plaintiff had gained her position only by performing a sexual act. And in that case, it found that that was a sufficiently severe instance of harassment there to qualify as sexual harassment. So that gives you a good sense of where the Second Circuit is on this, despite the sort of breadth and some of the other holdings that I described earlier. And then another case from the Second Circuit relating to the Rochester Genesee Regional Transportation Authority here, related to an instance of racial harassment in which the N-word was used. And they said, we emphasize that perhaps no single act can more quickly alter the conditions of employment and create an abusive working environment than the use of an unambiguously racial epithet such as the N-word by a supervisor in the presence of his subordinates. The use of racially offensive language is particularly likely to create a hostile work environment when, as here, it is presented in a physically threatening manner. And so this was an instance when a supervisor had yelled at a subordinate and had used the racial epithet while they were yelling at the subordinate. And so they found that that single incident, because of the context and the circumstances surrounding it and the use of that particularly offensive language, rose to the level of being sufficiently severe to be harassment without having to show multiple instances. With respect to pervasiveness, I think we're going to get back to that a little bit more later. But again, that needs to be sort of a continuous and concerted series of events. And it can be jokes, comments, physical activity, et cetera, that lead to this a pervasive environment that's hostile, intimidating, or offensive. Turning to the reasonable person standard, the thing we're looking at with all of these cases is what would a reasonable person in the alleged victim's or the plaintiff's position, how would they receive the harassment? So it's someone sharing the same protected characteristic, that's a reasonable person. And the idea here is to avoid being subjective in the way that someone who's particularly sensitive might be offended by a comment that a reasonable person would find to be innocuous. And so the perspective from which the evidence must be assessed is that of a reasonable person in the plaintiff's position, considering all the circumstances, including the social context in which behavior occurs and is experienced by its target. So that's important too, is you want to look not just at a reasonable person in isolation, but look at the surrounding circumstances of the behavior. Were other people around? Was the behavior public? Was it aggressive or intimidating? And things like that when you're looking at the behavior. And then this is turning back to, I mentioned before, the civility code discussion that the Supreme Court has had over the last 40 or so years. And this is a case on Kale v. Sundowner Offshore Services, which involved an all-male crew in which one of the crew members was harassed repeatedly over a period of weeks and months by other members of the crew on the drilling rig. So the prohibition of harassment on the basis of sex requires neither asexuality nor androgyny in the workplace. It forbids only behavior so objectively offensive as to alter conditions of the victim's employment, conduct that is not severe or pervasive enough to create an objectively hostile or abusive work environment. An environment that a reasonable person would find hostile or abusive is beyond the federal discrimination law's purview, and the same with Vermont's discrimination law. So again, we're thinking about, would a reasonable person in that situation find behavior hostile or offensive? Okay, so totality of the circumstances. When you're looking at these cases, you have to look at all the circumstances. And another holding from the Second Circuit provided here, the fact that men and women or people of all different characteristics within a certain protected characteristic, religion, nationality, disability, etc., are exposed to the same offensive circumstances on the job site does not mean that as a matter of law, their work is necessarily equally harsh. The objective hostility depends on the totality of the circumstances. So in other words, if a supervisor is bringing and displaying pornography at work, you have to look at the circumstances of the individuals who feel that the pornography is creating an offensive or hostile working environment. So just because members of the other sex may not find that to be objectively offensive, doesn't mean that it's not discriminatory if members of one sex would find that to be objectively offensive, or reasonable person of one sex. So that's an example from another Second Circuit case out of New York City with the police department there. And then from, again, turning back to the Harris decision, which is a US Supreme Court decision, whether an environment is hostile or abusive can be determined only by looking at all of the circumstances. These may include the frequency of the conduct, its severity, whether it is physically threatening or humiliating, or a mere offensive utterance, and whether it unreasonably interferes with an employee's work performance. The effect on an employee's psychological well-being is relevant to determining whether it was actually an abusive environment. But while psychological harm, like any other relevant factor, may be taken into account, no single factor is required. So you don't need to show that someone suffered a nervous breakdown or developed an ulcer because of the work environment. You take into account all of the circumstances, all of the impacts, and you consider them together. And this is where the subjectivity comes in, because it's weighing all of these different pieces. So facially neutral incidents may be included among the totality of the circumstances that courts consider in a hostile work environment claim, so long as a reasonable fact finder could conclude that they were in fact based on the protected characteristic. So this would include looking at incidents where maybe there wasn't sexist remarks or racially offensive remarks made, or discrimination against an individual with a disability. But you're looking at, so these things are neutral on their face, but they had a disparate impact. And they can create an impression about the totality of the circumstances surrounding the discrimination and can be used in sort of evaluating whether there is an actual hostile working environment.
Representative Dolan has a question.
Thank you for that. So what I'm taking away from this is there's a lot of gray area.
Yes.
Which is helpful to know, because I do think that helps us, like there's not a clear thing, like we really need to gather a lot of information to understand this. And I'm also understanding or taking away that the root of this is the impact on somebody's ability to work and perform their job duty. Like we need to really understand is XYZ behavior impacting somebody's ability to work. Is there case law or like how do we determine where it's impacted somebody's ability to work enough? You know, is it you missed a day of work or you couldn't do, like how, is there anything that gets to that piece of like shows like that was an impact?
Like
So-
performance standards,
Yeah, well, so
like performance standards.
No, of like it, because I think that that's a piece of this, right? That I think it says somewhere significantly impacts an employee's ability to, I forget where I saw it in there.
yeah,
I just want to know how we understand that standard.
I think there's two things that are at issue here. So it says significant impact on work performance or created an objectively intimidating, hostile, or offensive work environment. So, and the important piece of that is that while you can look to sort of concrete work performance metrics, as Justice Ginsburg wrote here, is the key thing is, did the harassment alter the working conditions as to make it more difficult to do the job? So you don't necessarily need to have a concrete impact on work. If someone is working extra hours or has a particularly, tough work ethic and is able to put their head down despite all the abuse, they may still be working in an objectively hostile working environment, and are entitled to equal protection under the law, even if we can't show that they're missing work or that their performance suffered. So that's the key where the reasonable person standard comes into it. And this is something that the courts have struggled with a lot too, because the reasonable person standard is not as concrete in terms of like when you say, well, their sick days out of work went up by 50% after the new boss started. That's a really concrete sort of thing to look at versus saying, is this an objectively offensive working environment? So you do need to kind of think of it as two different things that you look at. One is, does their work suffer, or is it offensive in a way that would make it more difficult to work in that environment?
That's helpful to clarify those.
Yeah, and just sort of continuing on that thought. So most of that is based on the experiences that'll be portrayed by the claimant within like an investigatory process, right? Like, I mean, we're really basing the environment of itself as depicted by the individual who's on the receiving end of the perceived harassment.
Right. So you're really looking at what does your investigation show. So it's not just, so you take testimony from the claimants, or from potential claimants, because this isn't a court handling a civil claim. You also take testimony from witnesses and bystanders, and also from the alleged perpetrators of the behavior. And from that, you create a picture of what the environment was like. You need to balance things like the credibility of witnesses, the possible mitigating factors. Was certain behavior that may have been perceived as discriminatory? Is there, if it's not objectively discriminatory behavior, for example, the use of a racial epithet or, a discriminatory joke or comment or something like that, if it's a facially neutral behavior that's being alleged as part of a pattern of discrimination, is there a legitimate business reason for the behavior? So, for example, and this is part of when you're in court, there's a burden shifting that goes on. So the plaintiffs will make out what's called a prima facie case, so sort of a facial case that they were discriminated against. The employer then has an opportunity to present legitimate business reasons. So, for example, an individual will say, I was passed over for promotion because of my protected characteristic. And the employer will say, no, they were passed over for promotion because they didn't have the necessary qualification for that promotion. So that would be an opportunity to rebut it. And then in court, the individual has an opportunity to show that the employer's reason is pretext for discrimination. So maybe there was an alternative certification that they did have, which would have qualified them for the job. This is, of course, a complete hypothetical and not related to what's in front of you, but as a panel here that's sort of looking at this issue, you're looking at not just the testimony of potential claimants, but information about the entire work environment and sort of balancing that information together to create a full picture and try to figure out whether that picture creates, what that picture tells you at the end of the day. Again, I don't want to get into the standards that you're going to be applying here because this isn't a civil court case construing the discrimination law. We're just providing an overview of discrimination law as part of because it relates to some of the allegations that are at issue in this case. Okay. Other questions? All right. I know I'm running over time, so I'll try to keep moving.
Important work. Thank you.
So turning back to the case law here, an important issue comes up when there's an issue of, well, the alleged or the potential claimant or claimant acquiesced or participated in the behavior. And it's important that you know that the fact that someone acquiesced in or participated in the behavior doesn't necessarily make it any more unwelcome, which is the key piece in the question here. So in the Meritor case, which the Meritor case was an exceptionally egregious case of sexual harassment. But the plaintiff in that case had participated in sexual conduct with the supervisor dozens of times over multiple years. And so one of the things when the lower court found against her, they said it was voluntary conduct, so it couldn't be sexual harassment. The Supreme Court ruled that the fact that she participated voluntarily doesn't make it any more unwelcome. This was her boss who had the authority to fire her. And the evidence in the case showed that she felt that she was under pressure to either lose her job or participate in the behavior. So when the court addressed that, they said, the gravamen of any sexual harassment claim is that the alleged sexual advances were unwelcome. While the question of whether the conduct was indeed unwelcome presents difficult problems of proof and turns largely on the credibility of the witnesses, The district court in this case erroneously focused on the voluntariness of the respondent's participation in the claimed sexual episodes. The correct inquiry was whether the respondent by her conduct indicated that the alleged sexual advances were unwelcome, not whether her actual participation in the intercourse was voluntary. So the turning to all forms of harassment here, if there is conduct that occurs in the workplace that's alleged to be discriminatory, the key question is, was it unwelcome? Not did people voluntarily participate potentially for avoiding scrutiny or displeasure of the individual engaging in the conduct. And so that again, as this notes, it's a very difficult question, but it's something that the question of whether it was voluntary is not what you're looking at, but what you're looking at is, was it unwelcome? All right, and then the next thing is ambient harassment. So this is harassment where an individual shares a protected characteristic with the target of the harassment, but they themselves are not necessarily the target of the harassment. The first case is, again, a Second Circuit case. Because the analysis of severity and pervasiveness looks at the totality of the circumstances, the crucial inquiry focuses on the nature of the workplace environment as a whole, and the plaintiff who herself experiences discriminatory harassment need not be the target of other instances of hostility in order for those instances to support the claim. The same thing applies for racial harassment, et cetera. So if you're in an environment where, say, racial comments are the norm, and you belong to a racial minority, you may feel like it's a hostile working environment, even though only 2 of those comments were directed at you. If there is a pattern of daily comments being made by supervisors to other members of racial minorities in the workplace. Does that make sense? Okay. And again, in Schwab v. Town of Avon, another Second Circuit case, the Supreme Court has cautioned us to consider the totality of the circumstances. The mere fact that Schwab was not present when a racially derogatory comment was made will not render the comment irrelevant to his hostile work environment claim. Just as a racial epithet need not be directed at a plaintiff in order to contribute to a hostile work environment, the fact that a plaintiff learned secondhand of a racially derogatory comment or joke by a fellow employee can also impact the work environment. So again, if there is this perception that this is going on throughout the work environment, that can impact the individual's perception of the work environment and could impact a reasonable individual. Again, we're asking the question, would a reasonable individual with the same characteristics in the same situation feel that it was an offensive, intimidating, or hostile work environment? So that brings me to the end of the summary of the case law. I'm going to turn to S-103 briefly. As I mentioned, this is still pending in the Senate. The language I'm going to review with you has passed both the Senate and the House at this point, and the changes in between the 2 bills are in other areas of the bill. So the first thing that S-103 would do is say that notwithstanding the precedents to the contrary, harassment and discrimination need not be severe or pervasive to constitute a violation. So this gets to what the chair was speaking to earlier, where the question of why don't courts just ask did discrimination occur? And Vermont is one of several or a handful of states considering this change right now. A couple of states have adopted the change at this point, but it's still the vast minority. We're talking about, I think at this point, 3, maybe 4 states have adopted it, and then a handful are considering this change. So, and probably the original adopter of it, to my knowledge, was New York City in the late 2000s. And so they've had it on the books for something like 14 years now. States have only started doing this in the last couple of years.
Representative Dole.
Sorry, I'm going back to the ambient. Just trying to understand the impact of that, because I feel like it's specific to, the situations we're looking at, but maybe there's examples of how maybe folks didn't think that it was a hostile work environment, right? But then there is a report that comes out and shares all this, like, whoa, like this was happening, and it makes you reflect and think differently about things. Like, is that part of that as well? I just feel like that's got to be because you're talking about a case where there's a joke that happened and they heard secondhand. So that makes you concerned, like, shoot, like, how is this going to impact my work and how I'm perceived at it? But I just thinking the example we have here is a whole report, and it just, if there's anything that can speak to that, like, I feel like that's ambient as well.
Yeah, I think, I think you're right. Now that the report is out, it does influence perceptions potentially. If there are instances there that individuals were unaware of in the office, and now it says, oh God, like that comment is now in a totally different light. I think that you're looking at I think you do need to look back to what was happening prior to the report. One thing that you do need to look at from the report forward is retaliation. And that is also ambient. So if someone who, if multiple individuals participated in the investigation, and one individual who can be identified is singled out for retaliatory behavior, that can create a chilling effect in the office. And so that any retaliation, I need to be very clear, retaliation or the belief that someone is about to engage or retaliation is illegal. And it is the most common way that employers become liable, because the standard of proof for severe pervasive harassment is a difficult one to meet. Retaliation is much easier to show, and but it is something that you do need to be conscious of, because that goes to a hostile working environment. It's the other side of the law. And the goal of the law is to encourage people to feel comfortable coming forward, to identify misconduct so that the misconduct stops. And so you do need to look at retaliation and look at whether the environment is chilling future reports of misconduct. But when you're looking at the sort of ambient environment for harassment, I don't know the circumstances post-report in terms of presence in the office and so forth. But most likely the most probative evidence is going to be what was the ambient environment before all of this came to light. And before that started, because that's what you're really looking at there, is how did people perceive the environment then, and so forth. That would be also a good question for the attorneys you're going to be speaking with this afternoon. Attorney Stackpole has a great deal of experience with the workplace investigations, but I would say you're mostly looking at pre-report. What was that ambient environment like then? Moving on with S103, the other thing S103 does is it defines harass, which I believe you asked about earlier, Representative Dolan. And so harass means to engage in unwelcome conduct based on an employee's protected characteristics that interferes with the employee's work. So you'll notice that this definition takes out the word performance to clarify that it's interference with work to be consistent with the Harris v. Forklift Systems concurrence from Justice Ginsburg, and creates a work environment that is intimidating, hostile, or offensive. You'll notice there's no use of the words severe or pervasive in there. The determination is made on the basis of the record of the whole, according to the totality of the circumstances, and a single incident may constitute harassment. Incidents that may be harassment shall be considered in the aggregate with varying types of conduct and conduct based on multiple characteristics viewed in totality rather than isolation. This is something I didn't touch on in the case law, which I think is worth pausing. So what this is getting at is very often, if an individual is the target of harassment, they may be targeted based on their sex and their race, or their religion and their national origin, or their ancestry, or whatever it is. It's often multiple characteristics that are targeted, sometimes 3 or 4. And so you'll find that an individual, they may have only had 2 sexually harassing comments, but they were also called the N-word. They were also called derogatory slurs based on the national origin or the national origin of their parents, et cetera. And so harassment is often a pattern of behaviors that don't stay within sort of the clean boundaries of a single characteristic. And it's also worth pausing here just to note that all of us in this room have protected characteristics, and we all have a racial background, a national origin and ancestry, a religion. Some of us have disabilities, and all of us can be targeted on the basis of those things. And it's just the fact that we're targeted on the basis of those things. There's no particular characteristic that isn't eligible for discrimination. So the fact is that you're discriminated against based on a characteristic. You can be discriminated against for any of those things. It depends on the environment. So that's the important thing to keep in mind here too. So we're not specifically looking at people that we might think of as belonging to one protected class or characteristic. And I don't like the term protected class because it involves putting people into a group like this group is protected and that group's not. Everyone's protected by the law, so I like to say protected characteristic because we all have those characteristics and we're all entitled not to be subject to harassment based on them. And then the final piece here in 103 with the definition of harassment is conduct may constitute harassment regardless of whether the complaining employee is the individual being harassed. This is ambient harassment. The complaining employee acquiesced or otherwise submitted to or participated in the conduct. The conduct is experienced by others outside of the protected class. So this can be ambient harassment or harassment that's sort of part of a generalized environment where use of racial slurs or other things are tolerated in the workplace. The complaining employee was able to continue carrying out their job duties and responsibilities despite the conduct, regardless of whether the conduct resulted in physical or psychological injury, and also regardless of whether the conduct occurred outside the workplace. I want to pause there because this always raises a lot of questions. Conduct that occurs outside of the workplace is actionable in an employment discrimination claim if it relates to the workplace. So if one employee starts targeting another employee on social media, for example, or starts seeking them out at the bars after work to sexually harass them, that could be part of an employment discrimination claim. The fact that one employee may post things on their social media account that another employee finds objectionable outside of work hours, and it's not a work account and it doesn't relate to anyone in the workplace, that likely would not fall under employment discrimination. So that's an important sort of line to be drawn. If you're looking at conduct that gets outside of the workplace, you need to have some nexus to the work environment for it to be employment discrimination. So again, this isn't a code that polices people's opinions or how they conduct themselves outside of work. It looks at how people conduct themselves in the workplace or how their behavior affects the workplace. All right, that's it for my presentation. I'm happy to take questions, but I'm also conscious that I've run 25 minutes over my time.
So I'm sure we will have questions in perhaps more of an as-applied basis as opposed to this overview. We have other experts that will have as well, but I think any other questions for folks at this point? Of course, Damien is, I won't say always available to us, but relatively available to us. So we'll plug it, we'll keep going if that's okay with folks. I know that Mike has to duck out, but he said it's fine and he'll catch up by watching on YouTube later. So we'll move on to our next agenda item, which we'll welcome Jennifer Carvey back to the witness, and then we'll go over an overview of what constitutes impeachable conduct, or at least some examples.
And my screen now. We should have this on the website. I'm not going to read through the whole thing. I figured I would just pick some points out of it.
Great.
So this is an overview of impeachable conduct. I think, as Damien said about looking at workplace discrimination, I think this is a topic we could spend a lot of time looking into as well. There are myriad examples from all over the country and at the federal level. So I just started out again by restating the House's authority to order impeachments and impeach state criminals. Makes every officer of the state, whether judicial or executive, liable to be impeached by the House, and then looked at the oaths taken, both the oath of office and also the oath of allegiance. So these are two oaths that all elected officials have to then themselves. So judicial, executive, military have to take before entering into office in this state. And so you'll see it'll come up in some of these examples, but also in some of the work that you're doing. I think we'll want to look at the oaths of office taken by the individuals and whether there's conduct that runs contrary to what they had sworn to do. So we have a couple of definitions of impeach from both the regular dictionary and the law dictionary. Impeach is to charge with a crime or misdemeanor, more specifically to charge a public official before a competent tribunal with misconduct in office. Also charge with a crime or misconduct, especially to formally charge a public official with a violation of the public trust. And I think, as this committee knows by now, but we use the term, people often use the term impeach to really refer to both impeachment and removal from office. Our focus here is just on what is actually impeachment, which is the charge. As I think you talked about a little bit with Betsy Ann last week, the clerk of the House, the Constitution, Vermont Constitution doesn't seem to set any specific standards for what constitutes impeachable conduct. Some other states' constitutions and the U.S. Constitution do. That means you have, as the General Assembly, broad authority to determine what the grounds would be on which an elected official can be impeached. That's for the House to do, and removed from office. That would be for the Senate after a trial. But I think it's helpful to look at what has happened in Vermont's history and also to look at some examples from other states and federal contexts. Also recognizing that some of those may be based in part on some of the language in those constitutions.
Mr. Chair.
Okay, all right. Go ahead.
Jen, I know I've missed more than an hour of testimony here, but a question I had in my mind during our several days that we had a break, this phrase, and I'm only raising this now because both of these things are listed in your write-up here, to impeach state criminals. The Vermont Constitution authorizes the House of Representatives to impeach state criminals. So I looked that up, and criminals isn't really defined anywhere in Vermont, but in Black's Law Dictionary, which I only use as an utter amateur, you have to be convicted of a crime to be a criminal, according to that dictionary. So can we impeach state criminals if the person hasn't been convicted yet?
So I think it's helpful and instructive to look at the law dictionary, but I don't think it necessarily governs the interpretation of Vermont's constitution. There has not been, to my knowledge, a Vermont Supreme Court case interpreting the language state criminal, but similar to at the federal level where high crimes and misdemeanors has been interpreted to be much broader than just violations of the criminal code. I think it is the opinion of both legislative counsel and House clerk, that the term state criminal as used in the Vermont Constitution is really as defined by the House in determining what constitutes impeachable conduct and commission of impeachable conduct.
So we decide what it is.
So you decide what it is.
Oh, wow.
Yes.
Okay.
It is a weighty duty, but based on interpretations by Supreme Courts in a number of other states that have similar language talking about crimes, the general consensus seems to be that it is not limited to violations of either statute or constitutional law.
So as a school teacher, I can send a fifth grader to a dictionary. She can look up a word and depend on that definition, but not with Black's Law.
I think, again, it can be instructive. I think the term state criminal is really what we're looking at. So it's not talking about criminals as used in the criminal code, but as a state criminal liable to impeachment. And so I think that allows for significant flexibility as fits the charge of the House in having the power of impeachment.
Thank you. Okay.
Right. So we're not, so just as the chair spoke this morning about this not being a judicial proceeding, I know we are not limited, you are not limited in your scope to what the courts might interpret terms to be in a court proceeding. Although if it were to come to the Vermont Supreme Court, they could interpret the language of the Constitution.
And I think what we get to, or what part of our charge or part of what we should do is look at precedent that there is. I mean, precedent of what other states have done, but also what has been done in Vermont over the past 200 years. And we'll see that it's not statutory crimes. It's not somebody who's been indicted or convicted of a crime. Just that precedent will show us that as well. That there's a confusing term having it there, but it should be looked at as really a term of art that we get to define the art on that. So
That scares me.
yeah. But again, we'll look to precedent, and we'll look to impacts on the work that we're expecting of these elected officials as well. I think that's what it comes down to.
Right, and just to be clear as well, the Vermont Constitution further on in Chapter 2, Section 58, when the Senate has the sole power of trying and deciding impeachments, talks about that their judgment cannot extend further than removal from office and disqualification to hold a future office, but the person convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So it's recognizing that there's the potential for separate processes and that this is not the same as a judicial proceeding that would determine somebody's guilt or innocence for purposes of violations of statutory law, but a separate process. So looking then at some examples from Vermont impeachments, we don't have a whole lot to pull from in Vermont history. Ras spoke with you last The most recent one we can look to, and the one we have the most information on, is that of Washington County Sheriff Malcolm Mayo in 1976. Most impeachments in Vermont seem to have used the term maladministration in part of the charge. It's unclear whether that was specifically due to what the person had done in each instance, or whether that is looking at language in the Vermont Constitution that provides that every officer in the state is liable to be impeached by the House, either when in office or after resignation or removal for maladministration. And if it's relying specifically on that language, as Clerk Rask said, it may be that that language is, or that reliance is misplaced. It may be an outdated reference to a former provision in the Vermont Constitution that allowed for the House to remove county officers for maladministration in office. But it is something we may want to keep in mind, and you may want to consider making part of articles of impeachment should you choose to recommend them at the end of your investigations. The charges do tend to be more specific and go on to allege not just maladministration, but also point to the conduct that formed the basis for the charges. So there were 3 articles of impeachment in the case of Sheriff Mayo. They charged that he committed maladministration in office in violation of his oath and duty, specifically through falsification of reports and documents, failure to perform the functions of his office, and breach of his duty as a peace officer. And it gave some specific examples that in support of each of those charges that I don't need to walk through now unless you'd like to, but are in here for your review. There are a few detailed records on earlier impeachments in Vermont's history. Only a few of those have resulted in convictions, the most recent being in 1785. There's also some bit of confusion in some of the earlier efforts at impeachment. Either the term impeach it sometimes appears to have been used maybe not to mean literally the kind of impeachment by the House that we're talking about, but the more antiquated version of charging someone with having committed some bad act. Also, there was some disagreement between the Council of Censors and the House about who had the authority to do what in the case of an impeachment. But in a couple of 1799 and 1800 impeachments, these were both against high sheriffs, one of Addison and one of Bennington County, and they were similar charges: maladministration of office by wittingly and willingly taking and receiving, for summoning a grand jury in one case, greater fees for services than were allowed by law under the cover of the office of sheriff, and very similar in the other case as well. Both of those were ultimately not pursued. The House decided that there were facts that the Council of Censors had not taken into account, and decided that their authority was discretionary under the language of the Constitution, much to the dismay of the Council of Censors, pursue impeachment. So again, just to sum up in those, the Vermont cases have used the term maladministration, whether necessary or not, but also go on to specify the other charges with more specificity. There's some examples from other states. There's a lot of examples from other states. I picked a few, either that were fairly recent or that had some, what seemed like particularly useful information. The language varies from state to state, but the common theme is generally that the person being impeached allegedly engaged in conduct that is incompatible with the public office that they hold. So I gave you examples from Arizona, Connecticut, Nebraska, and a very recent one from Texas. So the Arizona Constitution does have language in it, providing that the governor and other state and judicial officers shall be liable to impeachment for high crimes, misdemeanors, or malfeasance in office. The Arizona Supreme Court weighed in on what may constitute an impeachable offense in 1989. There we're looking at, and in fact did impeach the governor there. And citing from Lawrence Tribe, yes, on American constitutional law, they said there is almost unanimous agreement that offenses are impeachable when they involve serious abuse of official power. Those offenses include misapplication of funds, abuse of official power, neglect of duty, encroachment on or contempt of legislative prerogatives, and corruption.
What is encroachment on or contempt of legislative prerogatives?
They did not define, but guess, basing it on a later one that we'll get to from Congress, with one of the impeachments, recent impeachments of former President Trump. I think some of that is not obeying, not following, for example, a subpoena, complying with a subpoena from a legislative entity. So I think it's possible that some of these, and you'll see this in the Texas examples as well, additional charges may be added through the impeachment process or the investigatory process as the subject of the impeachment inquiry fails to comply with the process. In Connecticut, in 1983 and 84, the legislature there was considering impeaching a probate judge for mishandling of a very large estate. And they created an investigatory committee that issued a final statement of information. There is no specific standard mentioned in the Connecticut Constitution. So much like here, it was up to them to define or determine what constitutes impeachable conduct. Their final statement of information included some historical information, including a finding that the purpose of impeachment is to protect the state from abuse of power by its office holders, and that the emphasis of the impeachment process has been on the significant effects of the conduct in undermining the integrity of the office, disregard of constitutional duties and the oath of office, abrogation of power, and abuse of the governmental process. The committee went on in its report to suggest that the House should consider an official's course of conduct, not merely individual acts, when determining if impeachment is warranted. And it recommended 2 articles of impeachment in this case, charging that by his course of conduct, the judge did abuse the power of, undermine the integrity of, and bring disdain upon the office and trust he held by his course of conduct while serving as a judge of probate in a particular case, and by his course of conduct in furnishing under oath false and misleading evidence in official proceedings relating to that estate. And that he did abuse the power of, undermine the integrity of, and bring disdain upon the office and trust he held by his conduct in grossly disregarding the proper supervision and control of his employees and appointees, and by refusing to cooperate with official investigations of the probate court and of his conduct as a judge of probate. The House there in Connecticut did not end up voting on the articles of impeachment because the judge resigned, but it did engage in some floor debate and discussion about the articles. And so they have what seemed like some instructive thoughts on what might constitute impeachable conduct. Various members suggested that conduct that is improper, is wrongful, that brings disdain or disrespect upon the office, that violates the public trust, violates a position of trust, or constitutes an abuse of power. You're starting to see some themes. Nebraska is in here. Nebraska is a little bit unusual because it is the only unicameral legislature in the country. And so in Nebraska, instead of a House of Representatives ordering impeachment and the Senate conducting the trial, Nebraska, their constitution gives the legislature the sole power of impeachment. But if their unicameral legislature, which is all senators, orders an impeachment, then the Nebraska Supreme Court actually does the trying of the case. So a little different, but still some good language in some of their decisions. And their constitution says that officials are liable to impeachment for any misdemeanor in office or for any misdemeanor in pursuit of the office. So sort of getting back to Representative Brannigan's question here about state criminal and what is a criminal, I think typically the definition of misdemeanor would probably point to a maybe lower level crime as its definition. Here, the Nebraska Supreme Court has over a number of years, more than 100 years through its decisions, indicated that misdemeanor in office is not limited to violations of statutory or constitutional law, but instead includes neglect of duty willfully done with a corrupt intention and negligence so gross and disregard of duty so flagrant as to warrant the inference that it was willful and corrupt. And citing those earlier decisions, they held more recently in 2006 that there are 3 categories of conduct that may constitute an impeachable offense by a state officer. So sort of summing up those earlier points, an act that violates a statute, constitutional provision, or oath and is related to the officer's duties, a simple neglect of duty committed for a corrupt purpose, or a neglect or disregard of duty that is so gross or flagrant, the officer's willful and corrupt intent may be inferred. Moving on to Texas, the Texas Constitution does not have any standards or grounds for impeachment, but in 1924, its Supreme Court held that impeachment has a long history in English and American parliamentary law. It cited to a number of examples, and that it was designed primarily to reach those in high places guilty to official delinquencies or maladministration. I've got kind of a long quote, but it seems to have a lot of good stuff in it. The court said that the wrongs justifying impeachment need not be statutory offenses or common law offenses or even offenses against any positive law. Generally speaking, they were designated as high crimes and misdemeanors, which in effect meant nothing more than grave official wrongs. It goes on to say that in the nature of things, these offenses cannot be defined except in the most general way. The definition can, at best, do little more than state the principle upon which the offense rests. Consequently, no attempt was usually made to define impeachable offenses, and the futility as well as the unwisdom of attempting to do so has been commented upon. In the Constitution of the United States, impeachable offenses are designated as treason, bribery, or other high crimes and misdemeanors. Substantially the same language is used in many of the state constitutions. In others, misdemeanors in office, maladministration, oppression in office, and the like are declared to be impeachable offenses. Just last week, the Texas House of Representatives impeached, as you may have heard, its Attorney General, known as Ken Paxton, Warren Kenneth Paxton Jr., adopting 20 articles of impeachment against him. And so I have given some more detail on these than others, but I will just, for the most part, tell you what they were. They are 7 charges of disregard of official duty, 1 charge of misapplication of public resources, 2 charges of constitutional bribery, 2 charges of obstruction of justice, 3 charges of making false statements in official records, 1 charge of conspiracy and attempted conspiracy, 1 charge of misappropriation of public resources, 1 charge of dereliction of duty. And this specifies by violating the Texas Constitution, its oaths of office statutes, and public policy against public officials acting contrary to the public interest, 1 charge of unfitness for office, and 1 charge of, and I'll read you this whole one, abuse of public trust by using, misusing, or failing to use his official powers in a manner calculated to subvert the lawful operation of the Texas government and obstruct the fair and impartial administration of justice, thereby bringing the office of Attorney General into scandal and disrepute to the prejudice of public confidence in the government of the state. So, very recent example we'll be following, I'm sure, as you go through your process. Finally, we have examples from impeachments of federal officials. And we've cited in here, and I think we have discussed in the past, that federal officials may be removed from office under the U.S. Constitution on impeachment for and conviction of treason, briberies, and other high crimes and misdemeanors. And as I said, there's generally no specific definition of what constitutes high crimes, other high crimes and misdemeanors, much as there is no specific definition of what constitutes a state criminal under the Vermont Constitution. There's a lot of language in the U.S. House of Representatives practice manual talking about impeachments, among other things. And impeachments, it says, usually involve charges of misconduct incompatible with the official position of the office holder, with the conduct falling into 3 broad categories: abusing or exceeding the lawful powers of the office, behaving in a manner grossly incompatible with the office, and using the power of the office for an improper purpose or for personal gain. And I've given some examples here. The first comes from the articles of impeachment against Richard Nixon, one of which was that he used the power of the office of the presidency to violate citizens' constitutional rights, impair lawful investigations, and contravene laws applicable to executive branch agencies. There are many examples of federal officials allegedly acting in a manner grossly incompatible with their office. A couple of judges here, including an associate Supreme Court justice. The Judge John Pickering was impeached in 1803 for committing errors during trial in violation of his trust and duty as a judge. Associate Supreme Court Justice Samuel Chase was impeached in 1804 for various actions that were considered to be a breach of his duty to judge impartially and reflected here poorly on his competence to continue to exercise the powers of his office. And a more recent 2009 federal judge impeached for a number of bad acts, including allegedly sexually assaulting two court employees, obstructing the judicial investigation of this behavior, and making false and misleading statements to the FBI about the activity. In 1926, Judge George English was impeached for what was described as creating distrust in his official actions and destroying public confidence in his court. And in the Special Investigating Committee's report following its investigation, the committee determined the Constitution did not limit impeachment only to acts prohibited by the Constitution or federal laws, but also for those that affect the public welfare, and thus an official may be impeached for offenses of a political character and for gross betrayal of public interests, also for abuses or betrayals of trust, for inexcusable negligence of duty, for the tyrannical abuse of power, or for a breach of official duty by malfeasance or misfeasance, including conduct such as drunkenness when habitual, or in the performance of official duties, gross indecency, profanity, obscenity, or other language used in the discharge of an official function which tends to bring the office into disrepute, or for an abuse or reckless exercise of discretionary power, as well as the breach of an official duty imposed by statute or common law. As far as federal officials using the power of their office for an improper purpose, some of these examples included things like vindictive use of power against critics and political foes, and other types of language used in federal impeachments has included violation of the officer's official oath and violation of duty. Most recently, of course, at the federal level, we've had two instances of the House adopting articles of impeachment against former President Donald Trump. In 2019, the resolution contained two articles of impeachment, one for abuse of power and one for obstruction of Congress. The abuse of power charge alleged that the president, using the powers of his high office, solicited interference with the government of Ukraine in the 2020 US presidential election, which compromised the national security of the United States and undermined the integrity of the United States democratic process. And the obstruction of Congress charge alleged that by directing executive branch agencies, offices, and officials not to comply with subpoenas issued by congressional committees investigating Trump's alleged interference with the 2020 presidential election, the president abused the powers of his high office and interposed the powers of the presidency against the lawful subpoenas of the House of Representatives and assumed to himself functions and judgments necessary to the exercise of the sole power of impeachment vested by the Constitution in the House of Representatives. So that's that kind of interference with, I think, the legislative prerogative. While the House agreed to both articles, the Senate judged the president not guilty of each article in early 2020, and the 2021 resolution contained just one article of impeachment, incitement of insurrection, alleging that the president violated his constitutional oath of office and engaged in high crimes and misdemeanors by inciting violence against the government of the United States in his actions relating to January 6, 2021. Again, there, the House adopted the resolution impeaching the president, but the Senate adjudged not guilty. So finally, and by way of summary, there are a lot of ways to articulate the bases for impeachment. And to recap some of them: abuse of power, violation of the oath of office, violation of the public trust, behaving in a manner incompatible or grossly incompatible with the office. There seems to be different language used in different circumstances and varying by jurisdiction, but the theme tends to be that the subject of the impeachment has behaved in a manner incompatible with the position of trust to which they have been elected, and for the good of the state or the nation, as the case may be, the official should be removed from office. But there's also, throughout the cases that have taken this up, recognition that impeachment is solely a legislative power. And so the determination of the grounds for impeachment and what constitutes an impeachable offense or conduct is solely within the purview of the legislative branch, and therefore begins with this committee.
So would it be fair to say that we're going to look and understand the behavior of these two individuals, and really the bottom line is whether we think they should be removed from office because of that behavior?
I think that's right. I mean, looking at what the ultimate consequence of impeachment and conviction would be is removal from office and potentially the inability to hold a future office of trust in the state. Yes, I think that should guide.
And there's lots of ways we can, lots of examples of the language used, but that's kind of the bottom line.
I think that is I think that is the bottom line, that perhaps to some extent the language matters less than the purpose and the point of the articles, which is to